Good afternoon. Hello, Hawaii. My name is Mark Shklov, and I've been practicing law in Hawaii for about 40 years. Many of my clients come from the Asia Pacific region, where they have problems in Hawaii, maybe about transactions or investments in Hawaii. Also, I've been involved in international law practice for about 26 years in an organization called the Inter-Pacific Bar Association. I'm presently on the Council of the IPBA as a representative for Hawaii. Today, we have a program called International Arbitration in Hawaii, and there's a question mark at the end of that title. Maybe this program really is about a type of tourism. Tourism that's not the normal type of tourism we have here in Hawaii, with families coming to see the natural beauty of our islands and meet the warm and friendly people of Hawaii, but a kind of an economic type of tourism that could help Hawaii. Perhaps this is a legal tourism or a tourism that brings in businesses to resolve disputes. And we're going to talk a little bit about it today because we think it's important. Now, today we have a panel of experts who know a lot about arbitration, not only international arbitration, but arbitration mediation here in Hawaii. To my left, immediate left, Dick Mosher. Dick Mosher is an attorney, arbitrator, and mediator with the law firm of Anderson Kill. He is a member of the Neutral Panel of Arbitrators, the International Center for Dispute Resolution. He's on the board of directors and treasurer of the Association of Conflict Resolution and the chair of the Hawaii State Bar Association Alternative Dispute Resolution and Litigation sections, and is active in many other arbitration and mediation and bar association activities. Next to him, Jerry Clay has been in law practice since 1967, focusing on commercial and construction matters. In 1984, Jerry was trained as a commercial mediator. Since that time, he has mediated over 1,000 disputes. He is the immediate past president of the Mediation Center of the Pacific and is a fellow in the American College of Civil Trial Mediators and the National Academy of Distinguished Neutrals. His law firm is Clay Chapman, Iwamura, Pullis, and Nervell. And last but not least, of course, is Michael Ching Schwartz. He is General Counsel for Hawaii Dental Service, the largest dental benefits provider in the state of Hawaii. Over the past 12 years, Michael has worked with law firms in Hawaii and New York and has specialized in commercial real estate litigation and business transactions. Michael has arbitrated domestic and international claims in both Hawaii and New York. Prior to joining Hawaii Dental Service, Michael had been an attorney with Cage Schutte, the largest law firm in the state, for about 6 years. Michael lives in Alewa Heights, earned law degrees from McGill University in Montreal, Canada, and studied comparative law at Remnant Min University in Beijing, China. He received a Bachelor of Arts degree in economics from the University of Wisconsin-Madison and spent a year at University in Provence, France, taking economics classes conducted in French, which is the only language that I did not do poorly in because it's the only language that I didn't study. So I would now like to get this started and start off with the basics and ask Jerry to tell us a little bit about what international arbitration is and a little bit of the history of international arbitration here in Hawaii.
Sure, Mark. Let's start out with an example that might give an understanding as to why we have international arbitration. Let's assume that a company in Hawaii that provides visitor services gets into a deal with a firm in Uganda to provide services. And during the time that they're involved with one another, a dispute arises. I'll tell you, the Hawaii firm doesn't want to go to Uganda and try their dispute in the Ugandan courts because they may feel that they will get local justice, which will mean not in favor of a neutral result. And so what has developed in the international business community is a treaty. It's called the New York Convention. And this particular treaty, which is signed by almost every country in the world, says that if two treaty signers get into a dispute, that they can then go to international arbitration. And they would then say which dispute center they might go to. But the crux of this is that they would be holding their dispute before neutrals. And the most important part is that the winner would then be able to take their arbitration award to the courts of another nation, like the courts of Uganda. And the courts of Uganda, by the treaty, are obligated to enforce the judgment. And that gives it, the enforcement power gives it the teeth, the means by which we can do international business, because there is a way to resolve disputes and have the award enforced.
Okay. And as far as international arbitration, now I understand what you're saying is that it gives a way for us to arbitrate or to resolve disputes between foreign countries and ourselves in a way that we feel is impartial or fair.
Right.
Does it exist in Hawaii now, that type of thing, and why not? And what is the history of it here in Hawaii, of attempting to do that type of thing?
I think what you're really asking is, do we have a bricks and mortar operation here where people could say, let's go to Hawaii and arbitrate in Hawaii?
An international dispute.
An international dispute,
right.
Say between a firm from California, a firm from Uganda, can they come to Hawaii? And right now we don't have anything. And that is the reason that the four of us actually have been getting together and seeing if we can't make Hawaii a center where people could come here, have their dispute heard here, and then take that dispute back to whatever country it is that needs enforcement.
Have we tried this before?
Yes, we have.
And what is the background to that? Here in Hawaii?
Going back till the mid-'80s, I believe, we tried to establish a mediation center here in Hawaii. We went to the legislature to get legislation that said that that dispute could go to Hawaii courts to answer procedural problems during the dispute. But we never really got out there, marketed it, or sold it. And so it kind of fell by the wayside. And so now we're seeing that there are so many international disputes going on that Hawaii is just a logical place, particularly between firms from America and firms from Asia, or between firms from Europe and firms from Asia. It would be kind of a central spot. And not only that, but perhaps the litigants, the attorneys might even bring their families to do something while they're doing business.
And so an arbitration would be probably with respect to some type of a business or commercial dispute that arose. And in my understanding, these are pretty substantial in many cases.
Absolutely. I just read an article that there is a $1.6 billion dispute over the Panama Canal being enlarged, and that dispute is going to an arbitration center in Miami, Florida.
Right. I've heard a little bit about that. Okay, let me move on a bit and talk to Michael and ask him a question, because he has really been involved in the basics and trying to move this idea through various parts of our community, of our legal community. And I got to ask you a joint question. First of all, why and how did we start getting into this international arbitration concept again, after we've kind of started it maybe in the 80s and didn't go far? And then why is there now a question mark at the end of the title with respect to international arbitration in Hawaii, question mark? Could you lend us your thoughts?
I'd be happy to. I think that a couple of years ago, you and an attorney at Cades named Roger Epstein had been doing a fair amount of travel back and forth between China and other IPBA countries and Hawaii. And you had uniformly heard from people in those countries that there was a demand for Hawaii as a venue for international arbitration. And that led us to examine what we would need to market ourselves as a destination for international arbitration, and to be able to really advertise the quality of the members of the bar that we have here, the retired judges that we could serve as either arbitrators or mediators. And you gentlemen have been practicing longer than I have, but in the 6 years I spent in New York, I did a number of both domestic and international claims worth, in one case, at least several $1 billion. And I would say that the members of the bar that I met in Hawaii can stand shoulder to shoulder with the arbitrators, mediators, and counsel in New York, and we can provide as good, if not better, service, expertise, legal knowledge, and essentially the ability to resolve disputes than anyone on the mainland can. So then why not take advantage of our geographical location, of our wonderful weather, and really turn ourselves into a destination for dispute resolution. And by dispute resolution, I mean both arbitration and mediation. And I think, so to the second part of your question, you would ask, why is there a question mark after international arbitration in Hawaii? And the answer is, we really don't have the infrastructure on the ground yet. There are a number of procedural issues. We need to ensure that the members of other jurisdictions can come to Hawaii and mediate their disputes or arbitrate their disputes without running afoul of local licensing laws. We need a bricks and mortar location that Jerry was talking about earlier, basically so that if an arbitration is situated here, there's somewhere for them to call and someone will pick up the phone and they can administer the matter. And then we also need some empowering legislation. So that's really why there's a question mark after that. It's we, meaning the four of us, and the bar in Hawaii have to do several things in order to make ourselves a welcoming destination to international arbitration parties.
And the four of us have really been talking about this for quite a while, trying to get the interest from our legal community. And to us, it seems like a really low-hanging fruit in a way. It's something very, very easy for us that we could do, although there are some problems which we'll talk about after our break. Thank you.
You're watching Think Tech Hawaii, which streams live on thinktechhawaii.com, uploads to youtube.com, and broadcasts on cable OC16 and Alelo 54. Great content for Hawaii from Think Tech.
Aloha, my name is Richard Emery, and I host Condo Insider. We talk about issues facing the condo association throughout Hawaii and talk about solutions. When you think about it, about 1/3 of our population lives in some form of common interest real estate. We broadcast every Thursday at 3 p.m. Please tune in and thank you. Aloha.
Aloha, I'm Kirsten Baumgart-Turner, and I'm fortunate to be able to host Sustainable Hawaii at thinktechhawaii.com. I hope you'll join in with us every Tuesday from 12 noon to 1 p.m. to see the interesting people we have to share with you their information. Aloha.
Aloha! Hello, my name is Patrick Bratton. I'm host of Global Connections here at Think Tech Hawaii. We broadcast live every Thursday at 1 p.m. We bring Hawaii to the world and the world to Hawaii, talking about international events and various things of interest to the audience. Please join me. I look forward to talking with you and having you get to meet some of my guests. Aloha.
Okay, Michael, I'd like to follow up with a couple questions based on what you said. And one of the things that you were talking about was that you did some cases in New York, some international type cases. I'd like you to give us a little bit of a background, what type of cases we're talking about. I want people to understand what we're talking about, what we're dealing with. What are the types of controversies that are involved?
Very good. Okay. The cases that I dealt with in New York ranged from a French producer of champagne that got into a dispute with their U.S. distributor, and essentially it was a breach of contract claim, all the way up to arbitration of asbestos liability with probably 30 carriers, insurance carriers represented. I think in that case there was something like $7 billion worth of coverage on the table. Arbitration really comes down to a desire to avoid lengthy litigation in the courts, and so you'll find parties very willing, provided certain procedural and venue concerns are addressed, you'll find parties very willing to engage in arbitration.
Okay, and you mentioned that our geographical location was somehow favorable. Can you explain what you're talking about?
Oh, absolutely. First of all, there's going to be huge demand for arbitration between sort of North America and Asia. The Trans-Pacific Partnership, as we've heard about in the news, is coming. The TPP has a dispute resolution mechanism that relies on arbitration. And right now, the seat for arbitration is either Washington, D.C. or somewhere in Asia. And we hear from many parties that it's just more convenient for them to have the arbitration seated in somewhere like Hawaii because it's equidistant between the two geographical locations. But it's not only for convenience for the hearing. Even if you're in the stages leading up to an arbitration, if you're dealing with motions, scheduling conferences, anything like that, it helps to have Hawaii be 6 hours behind the East Coast and 8 hours ahead of Asia. Well, actually, Asia's around the other direction. But the point is you can have a scheduling call sort of in the middle of the day in Hawaii and have that be at the end of the day on the East Coast in the US and have it be at the beginning of the business day in Asia. It just lends itself to, it's very welcoming to both parties. Not only that, but culturally, when people come to Hawaii, anyone from Asia is going to feel at home here. Anyone from the mainland U.S. is going to feel at home here.
Okay, and Hawaii is the only state that I know of that can do that. We're the ones right in the middle of the Pacific, and we've held ourselves out for many years as being like a crossroads and I don't know if we've really ever fulfilled that promise. The last thing you talked about was a bricks and mortar type requirement.
Yes.
And now that's going to cause a lot of problems. But just before, without going into that too much, what do you mean by a bricks and mortar facility?
Well, to start with, I think we envision an administrative office. We don't need to have conference rooms or a mock court or anything like that that's capable of handling 20 people at once. One of the nice things about Hawaii's huge tourism and conference industry is there are any number of wonderful facilities available that can be booked. For the short term, we need essentially an office with at least one person there that can answer the phone, that can send out arbitration agreements for both parties to sign and to send back, and somewhere that can just be the neutral where either party can contact if they have any questions. So that really involves a desk, a phone, and probably an email address and a website.
So you're not talking about building a new establishment or a new building. We're talking about trying to use what we have to fulfill that goal.
Well, listen, if anyone out there is a true believer and wants to donate a building, we're happy to take it. But for the short term, no. It could even be run out of someone's law firm or anybody else's administrative office, at least for the short term.
Okay. Now, I want to turn to Dick and ask him a few questions because he's really been involved in a lot of international type arbitrations and mediations and knows the background of a lot of these international associations and centers. And I'd like to kind of get a feel for what the rest of the world is doing. And Dick, please tell us, what's going on in the world of arbitration, and I mean with respect to the world. What are we dealing with out there?
Thank you. There are several trends I think we need to be aware of, because a few of the constants are that the need for international arbitration and mediation has been there for many years and will continue. Hawaii's natural advantages have been there and will continue. But the trends we're seeing worldwide, we're seeing an increase in the number of arbitrations and mediations worldwide. For example, Singapore has had a huge increase to the point where they're actually reaching out to other organizations such as JAMS, which is a national U.S. organization, to help with some of the overflow. And it's not just in Singapore. Hong Kong, Singapore, more and more arbitrations. As litigation gets more expensive and takes longer and longer, and the attorney's fees and costs go higher and higher, there's more and more of a need. So Singapore, Hong Kong have already seen the trend and are reaching out for help because they can't handle it all. The same is happening within the U.S. We're seeing, and outside the U.S., Vancouver, Atlanta, Miami. There are several states who see an advantage to bringing in the business. New York is really an interesting example because not only do they have a geographic advantage with respect to Europe in handling disputes, but they've put out a marketing brochure which basically says, come to New York, attend our, go to plays on Broadway, make a time of it here. And of course, Hawaii has that advantage as well. And where better is there motivation to resolve things quickly so that you can wrap this up and get to the beach of the golf course? I mean, it's sort of an intangible benefit, but it's a real benefit. So we're seeing this big increase in the number of mediations and arbitrations. We're also seeing at the same time U.S. cities expanding and creating arbitration centers. In some cases in Miami, someone did pay for a facility. They've got a big fancy facility, financed partly by law firms and partly by others, where they can attract people to their center. And then at the same time, there's another trend going on, which relates to what we're thinking about here, and that is some of the arbitrations and mediations are getting drawn out and more expensive because either the mediation centers or the mediators, arbitrators are allowing more discovery. And as we know, discovery leads to lengthier hearings and more cost. And so to be competitive, Hawaii needs to do a number of things to keep up with the growing demand both in the U.S. and overseas. Michael described some of the advantages in terms of evening out the cost between the parties, but most of these international mediation centers, the basic fee is a percentage of the amount in dispute. The lower that percentage is, the more attractive Hawaii is. We've been talking about doing online mediations and online arbitrations. That would also lower cost. You don't have to be physically together for the entire proceeding. So there are some competitive advantages outside from the natural advantages of Hawaii that I think could help meet this trend of increasing number of cases.
Okay, now, so I'm hearing kind of two things here. You're saying there's a lot of international cases, and all of you could respond to this, involving arbitration, but I got to tell you, I've lived here in Hawaii all my life, and I don't hear much about this type of stuff in the legal community. I don't hear much about international cases, and I'm not sure why. Maybe Jerry can talk about that, but also, I don't know if we have in Hawaii the willingness to open ourselves up within the legal community, and perhaps Mike can talk a little bit about that. But you've mentioned that there are these locations in Asia, Singapore, Hong Kong, and I just came back from KL, Kuala Lumpur, and they have the very slick booklet that I got from their arbitration center. And I got to ask you, why are these? I mean, there's a lot of arbitration. I think I know the answer. The answer has got to be money. There got to be money in this for the arbitration centers. There's got to be a benefit to the venue. But what is that? I mean, am I right, or what, could you?
Oh, you're absolutely right. I mean, as I mentioned a minute ago here, the arbitration centers are charging a percentage of the amount in dispute for administrative costs of handling the arbitration. So if you get $1 million arbitration and you're charging a 10% administrative fee, you got $100,000, to help support the center.
So it's making sense for these international arbitration centers in Singapore, Hong Kong, KL, and wherever else.
London, Paris, I mean, you've got big centers in Europe where this has been going on for decades. And what we're beginning to say, Hawaii, wake up. And a number of things need to be done that we've talked about here. One of the problems that we have here right now is an ethical rule by our Supreme Court that says that you must be a member of the Hawaii Bar even in a arbitration proceeding. And one of the first things we have to do here is get the Supreme Court to say, let's amend that rule so that somebody could register here in Hawaii to practice only for this international case. That would be, for starters, the biggest thing that we can do. After that, then it's a matter of trying to get enough people in Hawaii to say, hey, this will be an attraction for people to come to Hawaii. What a wonderful industry would be international dispute resolution here in Hawaii.
So I kind of see this as a potential new type of tourism, if you will, a new type of business for Hawaii. We don't have it now. I mean, you three have a lot of experience in the area. Do we have anything like this now? Is there any international arbitration that is actually existing now?
There's a very small amount. I have been an arbitrator in an international case where I was appointed by the American Arbitration Association's International Center for Dispute Resolution, and being a sole arbitrator appointed for the case, the venue was decided to be Hawaii. But I think, and perhaps Dick or any of you can say, I think that's a very tiny bit of business. And what we're talking about is there's a huge amount of business out there. And that would attract people with money who would come here to spend money, probably at some of the more higher end locations. And it would be good for everyone. It would attract more people to Hawaii who might not think in terms of coming here for business.
Okay, now, it seems to me, from what I've seen, and I have a lot of friends in Singapore and Hong Kong and KL, that they're not stupid. And they have found a way to make some money for their country that we could learn from. And it doesn't pollute. It brings in people that are willing to spend some money and in business, and it brings a different type of a atmosphere to Hawaii. And I'd like to talk a little bit after our next break about the other American towns or cities that have these type of centers. Thank you.
Here's the deal. I'm Jay Fidel. I'm the host of Hawaii, the State of Clean Energy, which is the Energy Policy Forum's program on Wednesday. That's how we call Wednesday Energy Wednesday. We call it Energy Wednesday every Wednesday. Are you surprised? Okay, and we get guys like Jim Alberts here from Hawaiian Electric who can tell us what's really going on in energy. We want to be informed. It's so important. It's the most important initiative in our state. Clean energy is major, okay? And that's why we cover it on this show. That's the deal. What do you think, Sharon?
I think that's great. That's why we're here every Wednesday from 4 to 5, and we hope you all join us so we can hear people like Jim coming on our show and co-host Ray Starley from Hawaii Energy.
Okay, Jim, you've been here today. You've seen this. You heard what she said. What do you think?
I think it's a tremendous opportunity for people to come together and talk about the issues. Oftentimes, there isn't a good forum to bring these key issues out into the public, and this is a tremendous way to go about it. And the activity of this show is essential to keep talking about energy because, as you said, it's such an essential part of our lives that we need to pay attention to it and we need to think about the future.
Okay, Ray, your turn.
Well, this is a special time in the history of Hawaii where we're making some pretty radical changes in the way we use energy and generate energy. And this show is the one place you can count on coming to every Wednesday and hearing something about the latest issues that are on the table, being discussed, that will affect us all going forward. So come join us, and if you have some ideas you want to share with us about energy, give us a call and let us know. We'll put you up here and let you talk for an hour. So come see us.
Thanks, Ray. Thanks, Sharon. Thanks, Jim. It's great to be, from Think Tech's point of view, it's great to have this show. We love the show. It's our most important show. So come around and listen to us 4 to 5 on Wednesday. Thanks a lot. Bye.
Aloha.
Aloha.
You know, when we left off, we were talking about the international cities that have arbitration centers, that have established them for years, apparently, and find them as a good economic boost for their communities. Now, in America, we have some cities, Mike, maybe you could talk a little bit about that have also seen the value in having international arbitration centers. So I'd like you to go into that a little bit, please.
I'm happy to. And if you look at the cities that we've mentioned so far in our discussion, if you start on one side, we've mentioned Singapore, Kuala Lumpur, Beijing, then you go around to the other side, and we've mentioned New York, Miami, and Atlanta. They make a big circle, and for some reason, there's nothing really on the West Coast except for Vancouver. But California so far hasn't expressed a huge interest in attracting international arbitration. At this point in time, with the Trans-Pacific Partnership starting up and this huge generator of international disputes coming online, the business is really Hawaii's for the taking. And it's a tremendous opportunity for us to expand the expertise of the local bar and really become an international destination for dispute resolution. And this is a tremendous I wouldn't even say it's once in a generation, it's once in several generations opportunity. What we do in sort of the next 3 or 4 years may build a practice that will feed the next couple generations of Hawaii's bar. And that brings me to another point. This is not about taking business from the Hawaii bar. This is about bringing disputes to Hawaii that have no connection to Hawaii other than the fact that it's a convenient and desirable location for parties in Asia and on the mainland to come together and resolve their disputes. So this should create virtually no competition from the bar, for the bar. It should expand the opportunities for the bar to get involved in these types of things.
One thing that I did read about Miami especially is that they feel that their cultural ties with Latin America make them an ideal location for international disputes involving Latin America and Mexico.
Sounds like a good argument for us.
And it sounds, yeah, Dick, is this an opportunity that we should just take?
I mean, it's a unique opportunity. I mean, because the major cities on the West Coast can't make the same argument that we can in terms of, cultural knowledge between Asia and the U.S. We have a much stronger case to make than they do. And the number of lawyers we have out here that are experienced in these different areas doing business in Asia. We've got plenty of lawyers and law firms that are very involved in that.
And one thing that I've read, and I'd like you all to comment on, is that apparently in these international arbitration centers, including the ones in Asia and the United States, lawyers from other countries can come and participate in the arbitrations with various rules, of course, but they're not forbidden to do it.
Even more than that, Mark. That's absolutely correct. But what these jurisdictions are doing, Miami and New York, for example, is that they're marketing this. They're basically saying to the world, your lawyers can come here, and without being concerned about unauthorized practice of law in Hawaii, you can come here, represent your clients, and participate in the process. They're actively marketing this.
But Jerry, why is that attractive? Why would they want to be able to? Foreign lawyers want to come to a jurisdiction that has arbitration.
Well, I'll never forget when I first moved to Hawaii, and I went to lunch with a banker who said, look up at the sun every morning and say, that's why I moved to Hawaii. We are an ideal location, not just for people who want to relax, but for people who want to do business. You don't have to worry about packing your galoshes to come to Hawaii. And we are an ideal location because of our Asian ties to be able to say we are a welcoming spot. And lawyers do come here for vacation now. Wouldn't it be nice to have them come here and perhaps even bring their families here? It's almost a no-brainer. There is no downside to doing this. There is only an upside.
Remember, Oahu is the meeting place.
The name fits,
Right.
and we should take advantage of it. Now, Mike, what are your thoughts about, you know, the obstacles within our bar and the advantages for foreign lawyers coming here?
Well, the obstacle, it comes down to Hawaii Rules of Professional Practice, Rule 5.5, and that governs the unauthorized practice of law in Hawaii. That was further interpreted by a case called ODC versus Gould, which essentially said that the practice of law is broader than just representing people in court. The practice of law is representing other people where their substantive legal rights are involved, even if it's a negotiation or an arbitration. So based on that, the ODC has taken a fairly conservative position that a foreign lawyer could not arbitrate a dispute against another foreign lawyer. Recently, we've gotten some traction in discussions with the judiciary about maybe revising that rule. And you know, maybe Dick could speak a little bit to that because he's actually leading the charge on this particular issue.
I have had some discussions over at the Hawaii Supreme Court and received a very positive response. I think they recognize all the advantages of Hawaii as an international arbitration mediation center, and I think they're willing to work to find a solution. I mean, I think they have a legitimate interest in knowing whether lawyers are practicing in our state, even if they don't have jurisdiction over them directly. And so, you know, I think there are some possibilities. Lawyers who want to practice in our courts, there's a procedure called pro hoc vice, where they can get permission to practice on an individual case basis. So I think we're going to look at some options like that to give foreign lawyers an opportunity to come out here and represent their clients without worrying about Rule 5.5. And I think the Supreme Court has been very positive in saying they're willing to help us.
So that would mean a change in the rule.
Yes.
It'll be a change of mindset also.
You know, if I may, I think the Rule 5.5 as it's drafted now was designed with the concern of a New York company litigating against a Hawaii company, for example, and the New York company coming to Hawaii and bringing their New York lawyer, because the judiciary, their mandate is to protect Hawaii citizens. And in that sort of situation, you want to make sure that all of the parties are appropriately licensed. Of course, the judiciary has a similar interest when it's a foreign dispute, but when you have a New York party versus a Beijing party, the Hawaii Supreme Court's concern for their citizens goes down a little bit because their citizens don't have a stake in that particular dispute. At which point, I think the judiciary's concern becomes more sort of fair administration of justice rather than protection of their constituency. And that's why I think they're, rightly open to discussing the pro hoc vice admission proceedings for arbitrations.
And also, these are cases that wouldn't come to Hawaii.
Otherwise,
Exactly.
But for
absolutely.
the fact of having the opportunity presented, right?
That's very important. Michael's made that point, but I think you can go a step beyond that. You can say even if there are foreign lawyers participating in the process, there's still a benefit. There's certainly a benefit to the Hawaiian economy,
Certainly.
but there's a benefit to Hawaii lawyers to get more knowledgeable and involved in the process, and that's something we don't have right now.
Okay, well, just let me try to close this a little bit. I mean, first of all, do we have the mindset? Do you think, is this the right time for doing this? And what do we need to do? And I'd like you quickly each to maybe take a minute and just say, you know, are we ready for this, and what do we need to do? Dick?
We do have the mindset. No time better than now because of the expansion of international arbitration and mediation. In terms of what we need to do, we have a checklist of things from location of a facility to approval of the Bar Association to amending Rule 5.5. We've got probably about a 10-point checklist of things we need to do. We're working on it. This is the time to do something.
Jerry?
I couldn't agree more with what Dick is saying. this is the time. And there's going to be more international trade. With more trade, there's going to be more relationships that are going to go bad. And when relationships go bad, you have to solve them. And this is the time that we should be putting our chit out there to say this is the place to come to solve them. I have had talks with the Bar Association, and there seems to be support within the Bar Association to do this now.
Mike?
I agree with what both Jerry and Dick have said. I would build on that a little bit in that one of the other things that we need to do is revise Hawaii Revised Statute 658D, which is the international arbitration portion of the Arbitration Act. And to give you an idea how much momentum is building, I've actually had not one but two senators volunteer to introduce that empowering legislation when the time comes. So this is a wonderful opportunity. We've got the judiciary, we've got the bar, we've got the legislature, and hopefully the Hawaii Tourism Authority jumps on board too, because there's no downside to the state with this project.
Okay,
Mark,
I'd like to thank you
if
all.
If we don't do this, someone else is going to.
Some other state.
I would hate to be looking at LA in 10 years and going, we should have done that.
Thank you all. I appreciate your expertise. We wanted to kind of get this started and get the idea out there and the thoughts out there. I appreciate all of you being here today.
And thank you for organizing this.
All right, you're
Thank
welcome.
you.
Thank you for
Thank
hosting,
you.
Mark.
You're watching Think Tech Hawaii, Hawaii's leading digital media platform for civic engagement, raising public awareness on tech, energy diversification, and globalism. Great content for Hawaii from Think Tech.